I've had prospects to stop by my office and mention to me that they were interested in selling one of their relatives' property. I did my research. I discovered that the property was still in the name of the decedent. That's the person that had passed away. So I got back to the people that wanted to sell the house and mentioned to them that before I could assist you in selling the house, you will need to go file a probate petition to be placed in charge of the estate so you could sign on behalf of the estate. Hello again, this is Daryl Williams. I'm a real estate broker with Win-Win Realtors here in Southern California. Thanks for watching this video. On this program, we assist attorneys, executors, administrators, successor trustees, and conservators with real property that's going through the probate process. Today, we are identifying when is a probate necessary. If a deceased person owned real estate or assets that valued for more than $150,000, or if there were a couple where only one spouse was on the deed, a probate would be necessary. If you think of it like this, in general, a deceased person cannot sign any transfer documents in order to transfer that title to anyone else, including heirs and or beneficiaries. So a probate would be necessary. Here in the state of California, not everything in a decedent's estate has to go through the probate process in order to transfer to their beneficiaries. These assets are known as non-probate assets. They do not have to go through the court system in order to be transferred to the beneficiaries. Here are some of the examples. Pay on death contracts, such as life insurance policies, retirement plans, and IRAs. Assets in a living trust definitely do not have to go through the probate system. That's a big one. Assets passing from one spouse to the other. If a decedent had an estate for less than $150,000, there are lots of details with that, but here in the state of California, no probate is needed. If the decedent owned real property valued at $50,000 or less, no probate is needed. And I don't know too many properties here in Southern California that are $50,000 or less. Of course, these are not all of the details involved, but it gives you a great general idea. You have probate assets and you have non-probate assets. All probate assets will have to be transferred to the beneficiaries via probate court, probate procedure. Non-probate assets can be transferred to the beneficiaries via beneficiary designations and alike. Remember, even if your house is titled correctly, where if one spouse passes away, the surviving spouse can acquire the property without a probate, ultimately, when the surviving spouse passes, if there is no living trust, the property will have to go through probate. So in order to avoid that entirely, get some effective estate planning done. I'm Daryl Williams. This is Win-Win Realtors TV. Thanks for watching. And if this video has been of value to you, hit that like button. And if you like this kind of information and you find it useful, hit that subscribe button. And I'll see you in the next video. The information shared in this video is for information purposes only. It should not be misconstrued as legal advice. I am not an attorney. If you need a referral for an estate planning attorney, feel free to contact me.